This is a permission to appear in the matter of booking on an application of EK, MIK, and MAK, Children by the Institution of EK, and the government.
Mr. James.
My Lords, I'm not going to read out all of the representation because of the sheer number of distinguished counsel who are appearing before you, but you're going to hear, I think, from myself, the Secretary of State, Ms. Kilroy for the respondents, and there is, as I understand it, an application, if that's the right way of putting it, from the combination of Messrs. Southey and Devereux, who appear for Kent, to address you very briefly for 10 or 15 minutes, I think principally in response to something put in later on yesterday by the respondents.
Well, can we just deal with that briefly? There's been some confusion because I was expecting Mr. Devereux to attend. I wasn't expecting Mr. Southey, but it's always very nice to see him. But then we had an application for them to attend by CVP, which is why we had a slight delay while that's set up. And yet they're here all along. So I'm not quite clear. Why is a CVP link necessary?
My Lord, the reason for that is that the senior Kent lawyer responsible for it, effectively the head of legal, couldn't attend. We are seeking instructions. I know that the suggestion was raised that obviously it's on a live feed. The problem with that, having worked on that before, is that the way that works with
because of the delay.
Is the delay.
Well, no, let's not spend time. No, well, now I understand what the request has been complied with. Yes. So, but we won't have any remote submissions.
No.
That there was some confusion as to what was being asked for. That's fine. Now I may as well deal with the issue now of the note from the respondents and the issues which it raises about the Secretary of State's involvement in the inherent the family court proceedings are abusive. Three of us is that that's not likely to assist us or be relevant to the hearing that we have today. But we certainly won't invite Sir James to deal with his submissions. Ms. Kilroy may try to persuade us that it is relevant, in which case, of course, we will hear her.
Yeah.
And if, having heard her, we feel we would be assisted by submissions from you or Mr. Devereux, I'm not sure who said it'd be responsible for this, we will have to squeeze that into the time.
Well,
that won't, on any view, I think, be till the afternoon.
That's very helpful. The only thing I would just alert the court to in terms of what we were planning to say, because it may or may not be of assistance, is that Kent wants to emphasise very strongly that its position is not completely aligned with the Secretary of State. We hope that's clear from the evidence we filed.
It is clear from the evidence,
and
yes.
That was the thing that we wanted to particularly draw attention to, this is not simply Kent signing up to whatever the Secretary of State asks, far from it.
That was apparent from the submissions.
Thank you.
Yes, thank you. I just thought it was useful to deal with that now because it's relevant to why the CVP link was on right apart from anything else, and to the presence of Mr. Devereux and Mr. Southey. I think Ms. Kilroy wants to say something. Ms. Kilroy,
I just want to raise before the start of proceedings the anonymity application.
Yes, I was coming to all that, but not forgotten.
I don't imagine anyone objects to the anonymity.
No, all right, I will deal with it now. Anonymity should continue, and perhaps since we are being live streamed, I should remind all counsel to be careful. It's easily done, mentioning names or details. And more generally, I would just say to everyone here and watching remotely, it will be at least potentially a contempt of court for anyone to reveal the identities of the claimants or material that may lead to their identification. And I'm not sure whether a formal anonymity order has yet been drawn up, but perhaps you can submit a draft. Perhaps a draft has been submitted, Mr. Kilroy. Yes. Well, we will get that issued.
Well, I'm very grateful. And again, I'm not going to do too much on housekeeping. You've had a bewildering array of documents, including the usual last-minute documents. I think the position is that you should have a core bundle.
Yes.
You should have a supplementary bundle.
We have four supplements,
which has grown
numbered
exponentially.
1 to 4. Help
You
me.
you have 1, 2, and then 4 little 1, 4 little 2, 4 little 3, I think.
Well, it'd be done differently, but
We
I'm
need to
sure
go
we'll
there, we'll
find
try and
stuff.
identify
Yep.
them. And you have 2 bundles of authorities, I'm hoping.
We have, yes, I mean,
And I think the
one
divide is
bundle in 2 parts.
1 to 25 are the tabs for the first one, and then 26 onwards for the second.
Yes, I think that's right.
We also have something called a respondent's one.
You do, my lord, I was going to come to that. That's the last thing. I confess that I put all of supplementary bundles, 3, all variations of 4, and the respondents bundle in one file, but
Somewhere buried in that, will we find a hard copy now of the bundle that we were sent electronically yesterday, giving updated information about the proceedings in the including the order made by Mr. Justice Garrido last week?
not
I've
sure.
seen it bundled, electronic bundle with that in as the last document. But I couldn't find it in the plethora.
We're all in the same boat. We've had such a bundle electronically, and we assumed we were going to be given a hard copy here.
I'm just
There'll be an overlap.
I'm just checking. There's an overlap between one of the bundles, but this one is more complete. And contains all
The way I recognise it is it's got
the final order.
As a matter of prudence, so we don't have to waste time, if there is a further bundle in court, even if there's some overlap with ones we've already got, corresponding to what we were sent electronically yesterday, let's have it now. But maybe there isn't.
We've got one hard copy that we can hand out. That may or may not.
No, I think we want one. We want one each.
We'll make sure that one is brought over as soon as possible.
Thank you.
I've got it.
I have it on here as well.
Okay, well, I'll have the one. I'll have the one there is. I'm the only one here who is
I do
laptopless.
apologise that it hasn't made its way to you.
Sorry.
I do apologise that it hasn't made its way in a hard copy.
Don't worry, these things happen. Everyone's been under a lot of pressure. Thank you very much indeed.
Well, I'm hoping that deals with most of the housekeeping.
Yes, one thing you may count as housekeeping, or not. There are outstanding applications from both sides
Yes, sorry, I
to
meant to
admit
mention
further evidence. We propose to allow reference to all such evidence to Benny essay. Either party can, and that in practice it's more likely to be the respondents, indicate in their submissions the extent to which it's subjected to. But unless it's subjected to, we will simply admit it. But for the time being, we'll hear it to Benny essay.
I'm grateful. That's all I was going to propose. Thank you.
Oh, so, right. I have to have a hard.
We have now found some.
Oh my lord, so got a mini bundle. That's very nice.
Sorry, that's
Now, yes, well, sorry, Sir James, you had a lot of housekeeping to talk. You said you weren't going to do any. The other point just is, have you had an opportunity to talk to Mr. Kilroy about timetabling?
My lord, I haven't yet, but I'm anticipating that I will be probably till round about 12, maybe a little longer. And that should give us plenty of time to be done in the day that we've been allowed, I'm hoping.
Yeah, very well.
But you'll forgive me if I stray a bit from that, but the reason I haven't is because I know that we're both relatively short, so. Everyone's set.
I think we're all set. That's, we haven't done badly. Housekeeping in a case as complicated as this. Yes, well, let's get on to substance.
My lords, what I was going to just invite you to do is just to identify 2 documents to which I'm going to make relatively regular reference.
Yes.
And I suspect you probably have them loose or separate anyway. But our skeleton argument is in the core bundle at tab 6. And I'm going to have that as one of the reference points to try and save time.
Yes,
Page 43.
in the core
core
bundle
bundle.
tab, my lord saying he has no tabs. I only have tabs
Page
because my
43.
clerk put them in.
Page 43.
Yes, do we have a version with references?
I don't think you do, I'm
No,
afraid. can
we
always-
have from the respondents, but
help, I'm sure we can.
well, no, we can manage. But I just want to make sure I had the latest version.
I'll give you some references to where you find some of the authorities in due course.
Yeah, okay.
If that will help. And the other document, obviously, is the is the judgment of the upper tribunal that is appealed from, effectively,
Yes,
and that is in
that I don't have loose. but-
core bundle tab 12, page 221.
Yeah.
In the core.
Yeah.
Maybe worth just taking that out. It runs from 221 to 223. So if you have those two documents loose, that will save jumping around in the bundles.
Very well.
I was going to pitch straight in with the basic facts and to try and identify the basic facts which bear on the issues that the court has to confront. I don't think you'll need any persuasion. This is a potentially important case with serious and concerning consequences all round. The basic facts are these. On the 19th of July, and we'll call them the parents and the children,
Yes.
the parents decided to attempt to make the perilous Channel crossing so as illegally to enter the United Kingdom by that mechanism. They decided to make that attempt with their very young children aged 6 and 9. The perils of that course for the adults, and more especially perhaps for the children, do not need to be stated. No doubt in the chaos of that attempt, they were separated, with the result that the children arrived in the United Kingdom, along with others on the boat, and the parents remained in France, and that remains the position today. Let's go back a stage or two. The family are Turkish nationals of Kurdish ethnicity, and it appears that they travelled to Northern Europe. It's not entirely clear what the route was, but it seems clear that they went via Belgium, where they stayed at least for a period of time, and then they went to France. The parents wished to make an asylum claim, I put it that way, because the asylum claim that is posited is based, it appears, on a claim that the father faces, and thus in effect through him the family faces, persecution in Turkey in consequence of his political activities there. That's the nature of the asylum claim which is posited. And
Sorry to interrupt your
Yes.
flow. Just one point which the answer is probably somewhere in the papers, but I missed it. Has an asylum claim been made on behalf of the children in this country?
yes,
What was the date of that? Do you have that in your head? Someone behind you?
I've got that in my head, but I can find out the date. I
Okay,
think it was
thank
made
you.
following a welfare interview of the children by the Home Office.
Yes, fine. Sorry, go back to your sequence.
I was leaving them in France, having gone through Belgium
Yeah.
as a family. The children's position in relation to the asylum claim, as I say, is parasitic on the claim by the father. As to persecution in Turkey with the family exposed, no doubt it said as a result. My submission is that it would be entirely possible for the parents, and indeed for the children also, but for the parents, to make that claim for asylum in France. The parents assert that they do not wish to do that. And they have made some statement of concerns about, relatively broad kind, about their safety in France. The Secretary of State's position is that she does not consider that there is any proper factual basis for those claims. And indeed, the only evidence that appears to have been supplied in support of claims as to their safety in France is a single newspaper article in the first supplementary bundle at page 345 to 346. The Secretary of State's position is that there is nothing whatever to indicate that it would not be entirely safe for the parents to be in France, and there is nothing whatever to indicate that France would not properly consider and deal with any asylum claims from the parents made in France. Nor is there any, or could be any suggestion that if such a claim were to be made, that there would be any risk of refoulement from France before that claim had been properly and lawfully determined. That being so, it seems clear, we submit, the true factual position is simply that the parents would prefer to be in the United Kingdom and to mount their claims here for whatever reason. But that is a preference and is not dictated or driven by any legally recognised reasons based on safety or persecution. The present position is that the parents have not, as we understand it, in fact made a claim for asylum in France. And I'll come back, obviously, to the position that they take more generally in terms of their engagement with the French authorities in the context of the possibility of reunification of the family in France. That's an important point. That's basically the parents' position in broad summary. The children's position, in a nutshell, is this. They are being properly cared for by Kent County Council under, as I understand it, greater experts than me in court and on the bench, under Section 20 of the Children Act 1989. They are living with foster carers organised by KCC. They are attending school, and it appears from the evidence they are doing well at school. And they have been in daily contact, I think twice daily contact, with the parents by phone and on FaceTime. So they have at least been able to maintain contact with the parents. I'm sure we would all agree that it is hard, if not impossible, to see how the best interests of the children do not lie in being with the parents. And there is no doubt, we don't quibble with this, a trauma, at the very least, associated with being separated for a prolonged period from the parents. I do say only this about that, however. If there is or has been harm or trauma caused by the separation, and that is the positive assertion that the parents have been making in these immigration proceedings, see, for example, paragraph 42 of our skeleton, or the quote from one of the submissions put in at an earlier stage. If that sort of harm or trauma is being caused by the separation, it is, we respectfully submit, very difficult indeed to see why parents would not be both consenting to reunification in France and doing everything possible in their power to facilitate and bring about that reunification with their children in the shortest possible time. The legal position, as we understand it, under the Children Act, and again with the nod to the expertise in the court beyond mine, as we understand it, the legal position is as summarised in paragraph 13 of our skeleton, namely that if the parents objected to KCC continuing to accommodate the children and were willing and able to provide such accommodation, the local authority may not accommodate them under section 20, that's sub 7 of section 20, and they can remove the children from the local authority accommodation at any time. It is also, we submit, very difficult indeed, if not impossible, to see why any parent which could assist in achieving that result of reunification with the children would take the steps, in effect, would take steps, the effect of which might be to transfer the children not to them in France, but alternatively, as it were, into the French social care system. And it is of some significance in relation to all of this, recognising, of course, the caveats that Mr. Southey properly drew attention to about the cautious position of Kent County Council. It is of some significance that Kent County Council has made, on the 28th of November, an urgent application to the Family Court, invoking its inherent jurisdiction, it might be thought unsurprisingly, an application which seeks along with such other orders as the court considers appropriate, an order to return the children to France, to reunify the children with their parents. And I take that
Can we
language.
be clear about this? The evidence is that Kent brought those proceedings because there was at that stage no certainty, to put it no higher, that they could be reunified in this country, because entry clearance would not be granted, had not yet been granted, and there was no certainty it would be granted to the parents. Therefore, they thought that it was necessary for them to take steps to get the order of the court as to what should happen if there wasn't reunification.
Well,
in
yes,
the
I don't
country.
dissent from any of that. I'm not relying on the family proceedings in any other way than as part of the context, and they are premised on no entry clearance being the position and the Secretary of State's preferred position being, for the reasons given, no entry clearance. I don't seek to rely upon them, as it were, as a positive support for the position we take, but it is to be
Right,
noted
just
that that's
wanted to
what
make
they
that
are.
clear,
And,
and Mr. Southey would have.
yes, my lord, I gave you the form of wording which I took from paragraph 9 of Anne Nerver of KCC's statement, core bundle, tab 8, page 70, an order to return the children to France to reunify the children with their parents. The progress of those proceedings is set out at least up to the point of the date of the skeleton paragraph, R skeleton, paragraph 5.4, and I understand that the plan in relation to those proceedings is for a final hearing to occur probably in February 2025.
For 2 hearings, I think. One in January, dealing with legal issues, jurisdiction, etc., and
Thereafter,
a final hearing, as it were, on the factual substantive issues, depending on the outcome of the first hearing
in February.
in February.
I will agree. Those are the basic facts, anyway. And I'll come to aspects of them when I come to deal with the upper tribunal's decision. I wanted to indicate, however, 2 particular core and central concerns of the Secretary of State flowing out of those basic facts. The first is a concern that on facts such as these, the parents should not be able to engineer a situation in which their lack of cooperation with reunification attempts provides a basis for an English court to order that entry clearance be granted for the parents to reunify in the United Kingdom. And that is a concern which exists as part of broader concerns to seek to prevent disorderly migration, bypassing proper systems of controls, and to seek to prevent illegal entry into the United Kingdom, particularly if the form of that entry exposes all concerns, including most concerningly young children, to risks to life, as small boats crossing the channels when organised by gangs self-evidently does. There is a particular concern here.
Is this still part of your first concern?
This is still part of the first concern. It has the general aspect I identified and the particular aspect. The particular aspect for the concern, or the particular concern, exists here because, as the Secretary of State conceives it, there is no proper basis for any suggestion that there are safety issues in France. It is a safe country which is signatory to exactly the same range of protective international agreements that the United Kingdom is signed up to. Plainly, the parents can make an asylum application there, and it would be considered and dealt with properly by France, so we are not anywhere close to the sort of concerns that arose, as my Lord Vice President at least will well recall, in the context of Rwanda, with how applications for asylum are processed. A preference to make a claim and establish family life in the UK for whatever reason can ground, we submit, no rights. And reunification may well be, and probably is, perfectly possible in France. Whatever further work may be needed to cement the details of that And such reunification in France would at the very least proceed a great deal easier and quicker, and I'll take you back to some of the evidence on this in a moment, if the parents actually cooperated and took proactive steps to seek to make that happen. And as I say, there is a real concern if you can seek to frustrate that outcome, which it might be thought any responsible parent would seek, especially in the light of the positive assertion that they themselves are making of ongoing harm from the separation being prolonged. There'd be a real concern if parents in that situation could frustrate that outcome and thereby increase the prospect that a UK court would then order the Secretary of State to admit them to reunify here. So that's the first broad concern.
So James, before you
Well, of
leave that
course.
first one,
Yes.
can I just ask you this? Suppose the parents tomorrow consented to reunification in France.
Yes.
What, in practical terms, would happen? Would France be obliged to accept the children back?
Well, my lord, two things about that. That's an entirely fair question, if I may say so. Two things about that. Firstly, as a matter of practice on the evidence, the process would go a great deal quicker. I think the best evidence we have in relation to that, and I'll come to the reference in due course if I may, is in a meeting that occurred, I think, in early December, in which the French authorities estimated that if they got, as it were, that consent and that cooperation, it would all happen within 3 to 4 weeks. But my lord asked me a question specifically directed at the legal position, and my answer to that is that France is a signatory to the European Convention on Human Rights, and so it, as a state, owes obligations under Article 8 of the ECHR. And as I will take you to briefly in due course, because the case law is very well known, the basic starting point, and very often the end point, but at least the basic starting point in relation to reunification, reflected as it were in the Secretary of State's policy over here, is that children go to the parents. That the French would be under Article 8 obligations in circumstances where that reunification could be set up very quickly and organised and operated very quickly.
And does it follow from that if the converse situation obtained and the parents were reunified with the children in the UK, would France then have any obligations under the ECHR
No.
to take any of them back?
No. And that is exactly the converse, and that feeds into the balance of convenience point, which I'll come to in due course. But I will thank you for drawing those out. So that's the legal position, and it has the flip side. I respectfully agree.
But you are going to give your first heading, talk about the process, saying it would go a great deal quicker if parents cooperated, but speaking myself, I would still like to be given chapter and verse of what the process would be.
Yes, so
And,
far as
of
what
course,
I'm-
we know in general terms the process everybody seems to be looking at is under the Hague Convention, but you're going to go through those
I'm going to
details.
try and go through those in at least a little detail and show you roughly what that looks like. That was the first concern, therefore, which is effectively a gaming concern, if I can put it that way without being too disparaging. Parents being able to affect the likelihood of an English court making an order by deliberately taking a position which is, it might be thought, not consistent with anyone's good interests in terms of speedy reunification. Second is the broader picture of concern that you will have seen referred to in the evidence relating to perilous journeys being organised by criminal gangs who profit and are not terribly cute about safety across the channel. And the Secretary of State takes the position, I respectfully submit entirely properly and legitimately, that everything possible can and should be done to discourage those journeys. That discouragement and everything which operates as a discouragement, and indeed the flip side, namely things that incentivise those sorts of journeys or even more dangerous types of journeys might be incentivised, are strongly in the public interest to prevent that. The gangs profit, the journeys are perilous, lives are put at risk, all the more so if the lives in question are those of children aged 6 and 9. and indeed you've seen at least one authority in the bundles. This is Justice Gwyneth Knowles, I think, in the A case that you'll have seen reference to, where I think the basic background in 2023 was that parents were prosecuted here for exposing their children to those risks when they arrived here. That tells you the weight of public interest that we're dealing with. And that is a discouragement that has a more general and a more particular aspect. Sorry to load into those distinctions, still under point 2. The more general discouragement point is to encourage people to make claims for asylum in safe third countries such as France or Belgium before they, brackets, and their very young children, if they really choose to expose them to those risks, are put at risk. That is a powerful grounding public interest in reunification in France and not here. The more particular aspect is the one that we've summarised in our skeleton argument at paragraph 43.2, discouraging anything that might open up a new and even more perilous approach by the gangs. And my submission is that the evidence supports, and indeed there's nothing in the evidence to controvert this, it supports the real possibility, to put it at its lowest, of the gangs placing more children on boats if they can be pretty confident that the equation works on the basis of children in the UK equals a strong likelihood of the parents being able to follow. The risk is of positively encouraging behaviour which carries a greater risk to the generality of children. And I'll come back to Dr. Elimelech's evidence in relation to that. But I make at this stage simply the point that that judgment about incentivising the gangs to operate in that way, any sort of incentivisation when necessary for gangs to operate in the way that they do, is a predictive exercise in effect, which the Secretary of State is very well placed to make judgments about, given her and the police's developed understanding of how those gangs operate. And I also note, and I'll come back to this again and give you some references, that this isn't some dreamt up UK only parochial concern or prediction. This is a concern which is strongly shared by France. Where does this lead? And what steps need now to be explored, as it were? It leads, we submit, to a place in which the Secretary of State should not be compelled to admit parents in a situation such as this, whether on an interim, a fortiori perhaps on an interim, but whether on an interim or a final basis, unless and until all reasonable options for returning the children to France, preferably for reunification of the parents there, have been explored to an unsuccessful conclusion.
Hang on 1 second. Unless and until all reasonable options for reunification.
For returning the children to France, brackets, preferably to reunify, that's true.
Well, surely more than preferably to reunify.
Well, I agree, but I'm covering French social services versus cooperative reunion. No matter for the purpose of this point, have been explored to an unsuccessful conclusion, is the finish of the point.
And you will address us, I see obviously that submission, you will address us about timescales generally, but more particularly in this case.
I will. The key concern was and remains to seek through discussion and diplomatic engagement to do everything possible to ensure that France will facilitate and assist the return to and reunion in France. There are plainly routes for that, is a point to note at the outset. And it is agreed by France that they will facilitate and they will receive the children in France. I say the two options that have been thought about are either through what I call reunification, straightforward, consensual parents cooperating and all of that, or through placement into French social care and I'll come back to that in a little more detail if I may in a moment. I'm simply sketching at the moment, but see our skeleton paragraph 19 for that point. But I do emphasise that the easiest and the quickest way involves the active cooperation of the parents. They can, and I respectfully submit they should, do everything humanly possible to facilitate and speed up that process. And if they cooperate, they don't have any form, and they don't need to have any form of concern about returning the children into the French social care system, even though that may exist as an option with the additional complication potentially and the additional procedural requirements under the Hague Convention. See our skeleton at paragraph 20. And of course, if the route to France is, or is likely within a reasonable time to be, open, the Secretary of State's obviously preferred position, for all of the reasons I've indicated, would be not to grant entry clearance to the parents. To do so would be entirely inconsistent with all the conduct to date and would cut deep into the concerns that I've just identified. So we respectfully do not accept that there's too much circularity involved in relation to the family proceedings. The family proceedings are properly premised on the idea that the Secretary of State definitely does not want to grant entry clearance, and there is continuing doubt because of the nature of this appeal about whether or not the court in those circumstances would make or would uphold that mandatorily requires the Secretary of State to admit the parents. That is the backdrop against which we come to the core points on the appeal.
And I just, having reached a natural break, just ask one technical point, in case it doesn't come up later. Let's talk about entry clearance now, because that's what the application is for. I think the order was simply for admission, wasn't it? What would be the Secretary of State's intention if the order stood as to the appropriate legal basis on which the parents would be admitted? Would there be a grant of entry clearance, and if so, of what character?
Well, I think the answer to that is probably enough. We can fish out the details and make sure you have full chapter and verse on that. But there was a bust up, if I'm allowed to use a technical term. There was a bust up in the upper tribunal about the mechanism for compliance with their order if compliance had to be given when we were arguing about stay or no stay. And so those details were worked out in the context of those steps. And I think the position that was reached was, I may be corrected, I'll get the details, was that the position was that there was a form of rather less formal admission, which did not involve a formal grant.
Yes, there always used to be something called temporary admission.
Yes, well, I think
Remember
that was
being told recently that does not exist as such, but the substance is just physical admission and some form of immigration bail. But I don't think it matters.
No, but I will check and make sure you have chapter
one way or
and
the
verse,
other, we would like just to have that technicality ironed out one way or the other.
My lord, of course we'll do that. But as I say, I think there was a bit of jibbing at formal entry clearance being granted.
I didn't get involved in the details of what happened in that particular interval. But anyway, thank you. You where were you going next?
I was going to go to the judgment.
Yeah.
That is, as you know, and I'm going to essentially take the core strands of reasoning and use that as the building blocks for the submissions I make on the merits. I'm very well aware that the Vice President has invited all the parties to approach this on the basis that everyone should assume that we're obviously got to deal with the appeal points, but the court would like to be addressed about the position as it is today anyway. So I'm going to do both at once, but I'm going to use the judgment as the basis for the submissions. It's at 221 in core bundle tab 12 if you have it. Starts at 221 there. And you'll see it's stamped on the 4th of November but dated the 31st of October.
Oh.
Oh. Do you see that?
Mine is stamped the 4th of November, but
Yes, 4th of November.
oh, sorry, did you say 3rd?
No, I said 4th of November, and then it's dated on page 223, 31st of October.
I misheard, yes. We got the same one, of course. Yeah.
Yeah. I think that was a reflection of when the hearing happened
Yeah,
and
yes,
when
of
the
course.
order was made, and it was only stamped on the 4th, nothing significant terms in it. in case-
Again, just so that I know formally what happened, this order, as we can see, was date stamped on the 4th of November. It's actually dated the 31st of October. When physically was this? Did she hear submissions in the morning and produce this written document in the afternoon? How did it work?
Gave an oral decision. Written order and reasons followed.
I think it was, here's the result, reasons to follow, and the reasons then followed, I think, a couple of days later,
Yes.
2 or 3 days later.
Thank you.
Well, the first submission we make about the judgment, and we come back to paragraphs of it in due course, but the first submission we make about this judgment and indeed this jurisdiction is that the decision whether or not to admit people to the United Kingdom is a decision which is for the Secretary of State. She is the constitutional decision maker. And subject to the ECHR, she is of course a public authority and therefore bound to comply with scheduled rights under the Human Rights Act 1998. Subject to the ECHR, it is for the Secretary of State rationally to consider all of the circumstances, both personal and broader, public interest considerations, and to decide whether or not a person should or should not be admitted.
And just to be technical about this, not having had the answer, that would be so whether it was admission by way of a visa, or I say entry clearance, or any
Formal
kind of
entry
informal.
clearance under statutory discretion.
Yes,
Doesn't make any difference for this purpose.
there's certainly no difference. Yeah.
And so here, the Secretary of State is rationally entitled, and indeed it might be thought Thameside obliged, to consider the personal circumstances of the parents and the children, and also the broader immigration issues involved in a decision to grant some form of admission to these parents. It is not entirely clear what position Judge Kamara took in relation to this basic legal framework, leaving aside the ECHR. But Judge Kamara seems to have concluded that this was not a normal case in their language, so that the function of the upper tribunal was, or at least could include being, to quote, substitute its own decision for that of the Secretary of State. See judgment, paragraph 3. And that, I submit, as the first submission, is of real concern in principle, because it misunderstands the leeway that public law accords to the constitutional primary decision maker, both in relation to the final decision, which will be governed by rationality to admit or not to admit, but also in relation to the steps that are needed to get in all the relevant material in place. In other words, the inquiry duty and the consideration of what factors and all that.
We're all very familiar, obviously, with the constitutional position, and as you know, typically in a case where a decision is overturned and remains to be retaken, we don't, even though it may be logically inherent in our reasoning what the decision should be, we simply declare the legal position and remit it to the Secretary of State, trusting they will then make the correct decision. But there is a class of case, is there not? And you recognise it in your skeleton argument, where there is only one rational decision, the court can actually take the decision itself. Have I
Well,
not got that right?
there is a question mark about that, which
Well,
I'm going to come to,
I see.
which is under section 31(5) and 5A. It's what I call the RRR point, Lady Justice Elizabeth Lang's
Yes.
consideration of that in the present context. I'm not quite there yet.
Okay, well, I'm
simply
sorry.
at I'm simply at the base position of what is the public law duty on a Secretary of State who has a discretion. And the answer to that is they know discretion is unfettered. They have to comply with public law, and public law in relevant respects has two aspects: rationality of the final decision and inquiring into such things as rationally are required to be inquired into, and that's the Thameside duty. But both of those are primary judgments for the Secretary of State, subject to the public law control of rationality. And that, at least as it were, is the basic decision-making framework within which this sits, and that does not involve any form of substitution or ability of the court simply to jump in a particular category of case and say, I'm going to pretend I'm the Secretary of State in relation to either or both of those things. What we have here, however, is a context which involves the possibility of granting interim relief in a judicial review context. And here, of course, the nature of the interim relief sought and granted by the upper tribunal is in effect a grant of the final order sought, namely an order that they should be admitted to the United Kingdom parents. And on the authorities, that fact, that the grant of interim relief would in effect amount to the grant of final relief, in principle, and this is the second point, in principle adds real stringency to the approach that the court must take. I submit that perhaps the best description of the approach that the court should take in those circumstances is in the Zallis judgment at at tab 26, which I'm hoping is the first of the tabs in the second authorities bundle. And it's Mr. Justice Samey. And I really just want a single sentence, although, if you will, it sits within the context around paragraph 12 to 14 on page 503. And the single sentence I want, because the rest is well known, is the first sentence in paragraph 14. There are various ways of describing the more stringent test, but one can settle upon something along the following lines. The court must be satisfied to a high level of confidence that the claimant will ultimately prevail.
And this is specifically where the interim relief
Equals the final order.
is in practice final.
Exactly.
I mean, logically, you might think that it should be effectively a
final hearing.
Well, I was going to say equivalent to a summary judgment test.
Yeah.
But actually, the way it's put here is not quite as high as that.
It isn't quite as high as that, but my lord,
You're happy with that?
I'm content with that. But one sees the force of what is being driven at. It's just a description. And it might be thought, as I say, that if you're really doing a final order thing, then that's the minimum. What the judge did, if you go back to the judgment, is to consider that there was a need to show a particularly strong case, as it was put in paragraph 4 of the judgment. And that's the phraseology from paragraph 13 of Zallis, but paragraph 14 describes, I respectfully submit more accurately, the stringency of the test. But you'll see that the judge then becomes a bit equivocal on the nature of the test in paragraphs 5 and 6. I think, in fairness to the judge, the split that is being aimed at is perhaps the overall prospect of the applicant succeeding, as it were, the claimant succeeding, and then a focus on the children specifically in paragraph 6. I'm not sure. But you'll see the concern. The concern is that, having identified a particularly strong case, query whether even that is strong enough, given the point my lord has just put to me, and indeed given the true principle description that Mr. Justice Saylor adopted at paragraph 14, the judge then appears to have reverted to a real prospect of success.
I don't think that's fair, is it, Sir James? It's perfectly clear that she, perhaps unnecessarily, but is saying, first step, is there a real prospect of success? Secondly, is the case particularly strong? and that's how she does it in para 4.
By reference to the minor applicants.
But and then para 5 and 6, yes,
And 7,
yes.
the phrase particularly.
My lord, it does come back. I'm not just,
Yeah,
just
well,
saying there's at least a
I
question.
think you have better points than that. Well,
But anyway, that's the nature of the test, para 14.
yeah,
Whether or not it was faithfully and properly applied, whether particularly strong is to be treated as equivalent is a question. That's the second point, anyway. What's the nature of the test on an application for interim relief, which looks like a final order? And it does lead to the more fundamental RRR point that Lady Justice Lang was interested in the judgment that she, or the reasons that she gave for the stay. I'm sure my lords will have seen that. Is that a document that you recollect, the Lady Justice Lang?
I've seen it, I haven't reread it.
Well, can
Very
I just invite you
interesting.
to just go to the core bundle, tab 9,
Would you mind giving page numbers as well?
page 212, I'm so sorry.
Thank you.
Her reasoning starts at 210, and the point that I'm on at the moment is the point that she deals with paragraphs 10, 11 and, or 10 and 11 particularly for the purpose of this point, and 12, we'll see what she says.
A moment. Yes.
Yeah. If you go to the authorities bundle tab 1, the first one, keep the second one out if you would, because RRR is in the second one, so you might have to overlay. I'm after section 31 of the Senior Courts Act, which is behind tab 1, page 5 of the authorities bundle. See, this in effect puts judicial review on a statutory footing. Look at section 31(1), an application to the High Court 4, and then look at the orders referred to in 1A, and then look at the tailpiece wording of sub 1.
Yeah.
The one you're probably most familiar with, because it comes up very frequently, is the no difference test at 2 capital A at the bottom of the page. We're not worried about that. And then the key ones for present purposes are 5 and 5A, which need to be read together. Can I invite you just to cast an eye down, noting that the essential distinction between the two is that the authority, in other words, something that isn't a court or tribunal but is an authority, is not referred to in 5 capital A sub C.
Well, am I being slow? Surely you rely also on 5AA, don't you? I probably am being slow. I've just
Yes. Yes, it's 5 capital A, little a, and then B and C.
That's your point, that 5, subsection 5, paragraph A
Yeah.
refers to
Courts
court,
or
tribunal,
tribunals
or
only, not
authority.
authorities, in contradistinction to 5. That's the point. So what these provisions are doing are, at least at one very basic level, to reflect the fact that judicial review is a supervisory jurisdiction in which the courts respect the constitutional position of the decision maker, the primary decision maker, the person on whom Parliament, if that's what's happened, has conferred the discretion or the decision making function. And that means in terms of relief, normally, that if you find unlawfulness, you remit the decision to be taken again. Lots of shenanigans about these provisions when made, but that's the essential constitutional underpinning. But what 5A and 5 together do is to indicate that a court cannot, in a judicial review, substitute its own decision for the decision in question when the decision under challenge is that of an authority. And even in relation to a court or tribunal, you can only do it in the circumstance that my Lord the Vice President was putting to me, if there's no other option. In other words, the range of reasonable reactions was...
But there's case law, isn't there, on subsection 5, or its equivalent, that if there is only one rational outcome on the reconsideration, the court can and does do that. I've done that.
My Lord, I don't know whether that post-dated these sections
Yes,
or predated.
yeah, I did it
these.
earlier this year. In the divisional court.
I don't know what debate there was about 5 and 5A.
Well, there may not have been, but
Yeah.
you're right. What the court doesn't do is make the decision for itself. It doesn't say you're entitled to
No.
£100 or whatever the
It declares, and then
Exactly,
and then it says there's only one right out.
Yeah, and we expect the
Over to
executive.
you, get on with it.
Well, it's not just over to you. We expect the executive to comply
Yes,
with
well,
what the law is.
My Lord, you don't need me to tell you about the convention of the executive
Yeah,
complying,
yeah,
even
yeah.
if
So,
you make a
so those
declaration.
so those constitutional nuances are respected. I mean, I see force in your point, subject to submissions made by the other side, that you can't simply substitute if the critical word is substitute. I understand that, but in substance and in practice, you do often get the situation where
Yes, and there's nothing wrong with that. We're having a heated agreement, I suspect, because there's nothing wrong with the court indicating that there is only one rational outcome.
exactly. Yeah. That's all I'm saying.
Yeah, exactly. The
But there is
constitutional-
still a formal difference. And it could be a practical difference in a case perhaps where timing was important, where you quash the decision, you make it clear, maybe you say in the declaration, you certainly make it clear in your reasoning that there is only one outcome, so that it's perfectly clear what you are expecting the Secretary of State to do.
But the Secretary of State.
But the Secretary of State doesn't do it, or doesn't do it
I mean,
at once.
Then there may be enforcement questions.
Then there may be. You may be on a hamster wheel at that
Exactly,
point.
exactly.
But the answer is that there is trust. Probably. That's why you never get on the hamster wheel, because the executive can be expected to behave properly. That's why sometimes you don't need to make a quashing or a mandatory rule. You just simply make a declaration of the law, and the executive will then knuckle down. Can I just show you what Lady Justice Lang said, which is no doubt what triggered the paragraphs that you've just seen in her reasons? Can I show you what she said in the RRR case? Because it bears at least a bit on this point. It's in the other authorities bundle, this time at tab 34, if you would. Sitting with Lord Justice Nugent and Lord Justice Snowden, Lady Justice Lang giving the main judgment, and the paragraphs I really want, perhaps, and I'm going to invite you to read them if I may, and then I'll just pull together a couple of submissions on them. 76, page 723. This was a case about medical devices, and the basic context you can see from 85. But the first paragraph to read on the principle is 76.
Yes. 76.
Yeah.
Where now?
And then court will not readily restrain. 79, a basic principle from medical justice, just a note. Really, it's the point on the first line of page 724. Court will not readily restrain a public authority in the exercise of its functions. Then ground 2, don't need to worry too much about whether defalco has been overruled implicitly, but the key paragraphs, it might be thought, then are 88 and 89.
Yes, I've been looking at ex parte Shah overnight, and that of course long predates the statutory amendments. Yeah, so it's a long-standing common law principle,
Yes.
as I understand it.
It is, and you'll see her view expressed in 88 that Parliament has at least somewhat changed her position. That's the sting of what happens if you introduce the new provisions in the Senior Courts Act. And again, you may be dancing on the head of the constitutional pin that we were discussing, so
Yes,
it may be
well,
a squaring, but
this is interesting and important point, but suppose you are right about this and we accept that the judge was wrong to make a mandatory order because she didn't have the power to do so. But she could unquestionably have made a declaratory order of some kind, which made it absolutely clear if you thought there was only one thing that lawfully the Secretary of State could do, and you would in practice be in exactly the same position, wouldn't you?
well, my lord, there may be a question mark about that, because that would then tee up a set of arguments that say actually what Parliament has done in these provisions is to set the parameters of what a court can actually do, and if what the court is doing is simply a device to get round that, it may be problematic in the light of the provisions.
That wouldn't be a device, that would be just what for the reasons you just given. If she had done that and you had not appealed, the Secretary of State would unquestionably, maybe through gritted teeth, have complied.
She would.
Yeah. Well, so I agree this is important that we get it right in any judgment we do. But it doesn't really go to the heart of the issue in this case, does it?
I'm not sure it does, but I wanted to flag it up because Lady Justice Lang was very interested in it. And it's not an entirely straightforward thing to see how constitutionally it all hangs together. I've shown you the nature of her reasoning. There is a kind of base question about whether or not how far the preclusion in the statutory scheme which now governs JR goes. But there's also a separate point which goes, even if you're not convinced that there's a jurisdictional shutout, to the caution, to the reluctance that a court
That you've
should
already
have.
addressed us about, and we quite understand.
Well, I've already addressed it about it, subject to the one point that one can take from these two paragraphs, which is that all the more caution is needed, if I can put it in that way. I'm not abandoning the jurisdictional point. It may become important at some later in some later venue or in some later case. But what Lady Justice Lang was particularly concerned about was the idea that someone should make on an interim basis a mandatory order when you haven't even had the future decision. And in here the context is, do you admit or do you not admit? You haven't even had the decision making in relation to that. A strong preference is evident from the
Also, when the Secretary of State then remakes the decision, she doesn't make it on the basis of the facts that existed, just on the facts that existed originally. She takes into account everything that's happened since.
She would. She'd have to take it on the basis of present circumstances.
In any situation like this, very fast moving, the facts are bound to be different.
They are. And my lord, that is why I emphasised as part of my first point exactly that. Not merely the final decision rationality thing, but the Thames side thing, and taking into account all the circumstances. Circumstances may change, lines of inquiry may need to be gone down. And my lord, so I emphasised that other bit. I really don't want to spend a long time sucked into a pure jurisdictional point.
These are quite deep waters.
They are deep waters, but I wanted to show you the depth.
I mean, that when you're dealing with convention rights, there may be a convention angle to it too.
Well, that would raise very different questions.
You accept that?
That would, well, because then there would be a statutory obligation
Exactly.
to comply under the Human Rights Act, under Section 6.
Right. So, but how does Section 6 sit with, can you read down 31(5)(a)? That's really what it would boil down to in a case where...
I'm not sure, because then you might get into all sorts of debates around the fact that Article 13 was not one of the scheduled rights.
Yes,
the provision of an effective
the
remedy.
more we go
Again,
into it, the less, the more it's clear we shouldn't go into it unless we really have to, and I don't think anyone is suggesting we really have to.
One factual point, Sir James, that you can help me on, if you kindly remind me.
Yes.
You have emphasised and I understand why, that this was, in form at least, an interim order.
Yes.
Is it still envisaged by the upper tribunal that there is going to be a final hearing? The final application will be adjudicated.
My lord, I think it is.
And is there a date when
I
that's
think it
going
is. The dates have been banded around.
A directions order was made. I forget whether it had a date in it, but it set up an early hearing.
Can somebody just remind me when that will be?
9th of January.
9th of January. Well, that's not that long to go now.
Yeah, just which feeds into justification for an interim order in any event, in the nature of a final order. But they certainly are envisaging having a hearing.
So if the appeal succeeds, what happens then? Because if that final hearing goes ahead, does it? At which this issue will be reconsidered?
I suppose so, but the parents would be here. If the appeal, if the appeal succeeds, then
In theory, the hearing goes in on the
Hearing
9th of
goes ahead.
January,
Yeah.
which is before Mr. Justice Guido has returned from the vacation and had his first hearing.
Yeah.
But nonetheless, the situation, you would say, would be factually different from how it was in
it certainly would, because there's been
Mara's hearing.
progress in discussions with the French and so on.
Forgive me, if the appeal is dismissed and the upper tribunal order stands,
Yes.
then on your submission, will the hearing on the 9th of January take place?
Well, I suppose it would, but it's very difficult to see quite what practical import it would have, not least because all of the public interest concerns that I've identified that the Secretary of State, I respectfully submit, properly has, would risk having been created. All of those concerns would have happened anyway. It may be possible at that stage for...
No, I mean, in a sense, the problem isn't there, because if the upper tribunal said, having heard further argument, now realising there's a possibility of being reunited in France, I discharge my previous order, and this will never happen again, then the right message will have been sent out. All that would happen. The problem is the practical problem. By that stage, as you say, they're here.
Yeah.
There's no mechanism for removing them unless the French agree, and that'll be a completely different situation. In which,
with the French not under an Article 8 obligation that they were previously under,
quite,
and with all the weary ways that we know happen when people arrive in these shores and make their various claims
yes,
to state.
I think somebody named Ms. Kilroy may say, I think there is a hint to the contrary in her an argument. It's hard to see that in those circumstances it will be possible to return them. But that will be the problem. Not that the judge could say, this I should never have made this order, and I can tell you I won't be making an order like this again. Now I've heard all the arguments. And in theory, the gangs will not think this works.
Yeah, well, that's the theory. And the theory,
There we are.
the theory rather depends on what the nature of the judgment is and how far they want to
No,
say
I
in the future.
understand.
but
I understand. I've just
But yes, you're right. The
Yeah.
practical concern is the central one. And I'll come back to that on the balance of convenience, if I may. Anyway, my lord, I hope I haven't wearied you with RRR, but I thought you ought to see it.
no. It was a point that
It was obviously a matter that concerned Lady Justice Lang, and
Yes,
I suspect we may not need to get there here, but if we do, there is the point, and that's the shape of it.
thank you.
So that was the third submission, and effectively those were the 3 points about the principal approach in relation to the appeal of significance. The next point is, or next submission, the big submission perhaps, is that there is no proper basis, there was no proper basis for the upper tribunal to have made the mandatory interim order in the present case anyway. And all of the matters I went through in opening this, and I try not to repeat unnecessarily, were highly relevant, including public interest considerations to be taken into account, including in particular, and I'm going to identify 8 short features or facts, including in particular 1, the fact that the parents could have claimed and could claim asylum in France, and that the children could do so too. Indeed, the children's claim factually appears to be entirely parasitic on the claim by the father. Secondly, fact number 2, the fact that there was no proper basis for any claim that the parents are at risk of persecution in or would be unsafe or are unsafe in France. So, 3, it appears clear that we are simply dealing not with the exercise of legal rights or freedoms, but with a preference to be reunited on the part of the parents in the United Kingdom. 4, the fact is that the children are being safely looked after in England in the meantime and are keeping in communication with the parents and are going to school and all of that. We've seen Kent County Council properly performing its caring obligations in the meantime. 5, the fact that the French were and are willing to facilitate the reunification of children to France. And there are, in principle, perfectly viable routes to enable that to happen, including under the Hague Convention if necessary, but shortcutting it all, parents cooperate.
Well, now, just so far as that is concerned, you will have to show us the extent to which there was solid evidence before the judge, if that's what you're dealing with, that was the case. You may say things have moved on.
I'm going to do that if I may. Can I just give you the 6th and the 7th one, and then I'm going to drift into the evidence. I'm going to go to the evidence on French willingness.
Right.
6, work is needed, and was a fortiori needed at the date of the hearing, to put the detail of those arrangements together with further discussions which France was willing to undertake. But detail needed to be worked through and still does. 7th, but in short, there is and was a real prospect of achieving an open route after those discussions had successfully concluded within a reasonable time frame. The evidence on the French willingness, the headline point is that it's clear that France is willing.
So is this is a development of point 7.
It's a development in effect of points 5, 6 and 7.
You did say there were going to be 8. Is there an 8th?
There's going to be an 8th one.
Back, coming
The 8th one is coming, or the 8th and 9th one are coming,
Oh, right, very well.
but later. But we're going
Okay, we
to
get
concentrate
one
on
extra.
French willingness, if I
Right,
may, for
okay.
the moment.
Okay, but developing in French willingness, yeah.
Headline point is it's clear that France is willing to accept the children in principle. And the evidence on the timings and progress of the French discussions are that the discussions with France had commenced at the date of the upper tribunal hearing. One sees that, I'm not entirely sure what instructions were given and how that was put at the upper tribunal hearing, but one sees the reference to discussions with the French, albeit at an early stage, as the tribunal put it in the judgment at paragraph 8. There had been positive indications from the French in August. That was set out of their willingness to engage and to have the children back. That was set out in the detailed grounds, amongst other places. Paragraph 16 of the detailed grounds, core bundle, page 306. I'm going to turn it up.
The judge, you said the judge referred to it. She said at a very early stage.
Yes. But
So, what was the reference in the detailed grounds?
detailed grounds, para 16, core bundle 306. There had been contact in September 24 with between the Border Force France engagement team, as it's called, and JCWI, the solicitors for the family, noting that the prefecture of the Pas-de-Calais wanted confirmation as to whether the parents were present in the region as they lost contact, and asking for contact details for the parents if JCWI would be happy for them to be shared with France. And that led to agreement from JCWI, as I say, inviting the Secretary of State to pass those over. That was on the 14th of October 24. Supplemental bundle number 1, page 338.
Supplemental bundle 1338.
338. There were then some further exchanges between the Home Office and the French authorities, which don't take the matter too much further, but
It
they're
helps to have date. If you're giving us a summary, a dated summary would be most useful. So 14th. What's these?
that was the September was the contact with.
We haven't got a date in September. 14th of October.
Was the reply saying yes, pass them on to the French from JCWI. That's in supplemental bundle 1.
Yeah, it's
339.
Okay. And then you were saying some further contacts with the French.
Further contacts 10 to 24 October. Further contacts between the Home Office and the French authorities. Don't take the matter much further, but see supplemental bundle 4.2 at pages 3 to 4, 6 to 8 and 33.
Hang on. Yeah.
Then there was discussion on the 29th of October with the French reiterating, as it were, in principle agreement to the reunification of the children with the parents in France. And you get that from, I'm going to refer to her as ME, if she'll forgive me, Dr. Lemnick statement, ME2, second statement, paragraph 6.
It's all summarised in her fourth statement, isn't it?
It is all summarised in her
Pulls
fourth
it all
statement.
together in the fourth statement.
It does, which repeats it.
That's right, but if I may respectfully say so, certainly in my mind, what's going to be important is for us to know precisely what was before the upper tribunal judge. Was the second witness statement before the upper tribunal judge?
No, only the first was before the upper tribunal judge. The second came after.
Was the meeting, I forgot, was the meeting on the 29th of October before the hearing?
The meeting was before the hearing, which was the
judge
31st.
Told about it.
The judge was told about the meeting, but the minutes of the meeting wasn't provided until after.
So I think the fact of the meeting, sounds like the fact of the meeting was put before the upper tribunal,
But not in evidence.
but not in evidence and not the note of the meeting. Indeed, I'm not sure even the outcome of
So
the meeting.
the assertion in the statement that the outcome, they agreed in reunification with the children with their parents in principle, that wasn't put before the Judge Kamara.
As I understand it, that was not put before Judge Kamara in those terms. The fact of the meeting was put, but not the content of it. So the furthest one goes on positive indications with paragraph 16 of the DGs, the reference to which I gave you earlier.
Yes, but Sir James, I think you would submit that even on that limited evidence, the upper tribunal erred in principle in not allowing the Secretary of State a reasonable amount of time to pursue those
discussions, early stage though they may have been. And they knew discussions were on foot. And everyone knew that there had been discussions about providing details to the French authorities and trying to work out where the parents were and so on. But I don't want to overstate it. The ME's statements cut in at number 2, I think from the 13th of November. That's the date of the second statement. So they were not before the upper tribunal, even though one of the annexes to the second statement was a note of a meeting which happened before the hearing of the 29th of October and indicated that agreement in principle. That doesn't seem to have fed through to the council team then representing the Secretary of State. So I don't make a positive case that that was before the upper tribunal. Can't do that. And the progress thereafter, as my Lord Justice Baker has rightly pointed out, I could give you lots of references, but probably the key pulling together of the progress subsequently, as it were, is in the fourth.
And where we are now,
Or
as
where
the
we are
Lord
now.
says, if we're looking at what the judge knew, it's
It's-
in the first one.
It's in the first one only, which doesn't refer to discussions with the French in terms. You only get that from the DGs and the fact that there was obviously some discussion about discussions with the French because it features in the judgment.
Yes. But just to summarise, as you agreed with what my Lord Justice Singh put to you, that you would say even if we were confined to deciding whether the judge erred on the material before her, she did err because she had enough
To know that the discussions
to
with the
know
French
the
were
time
ongoing
and therefore should have given more
and what
time.
they were about.
Yeah, quite. what is the if we were to admit the further evidence, just put the correct jurisprudential label on the basis on which we could overturn the judge's decision on the basis of material which she wasn't aware of, and or hadn't even happened.
Well, if you conclude that she went wrong in principle, that might open up a jurisdiction on you to consider matters afresh, as it were.
And if we didn't find she went wrong in principle,
then it's more difficult to accept. You've got to get to that jump, as we know from Miranda. You've got to get to that place first. You can't just start revisiting. But my submission is that it is evident that she was aware that discussions with the French were continuing. It is evident that she was aware also what those discussions were designed to do. The entire position of the Secretary of State, I don't want to grant these parents entry clearance because I'm deeply concerned about what that would entail. And that's what led to the reasoning in paragraph 8. Well, I don't need to pay any attention to those discussions because they're early.
But what is the position if she had not erred in principle, but there had been a material change of circumstances before her order had been implemented?
Well, I suppose that might be different, but I'd be a bit reluctant to go too far down.
No, I'm just.
The natural
want to
course
think
would be
this
to
out.
reapply to her.
Sorry?
The natural course then would be to reapply to her.
Yeah, so yes. There certainly is a jurisdiction with an interim order to reverse it, an A fortiori if it hasn't actually yet been complied with, if there has been a material change of circumstances. But as you also say, the normal course then is to go back to the person who made the order.
And I suspect that by then everything was moving at such speed.
Yes, I'm not criticising anyone.
No,
I'm just
but there were arguments about whether or not we needed what we needed to do, and when
your primary case is the judge went wrong at the time.
It is.
And then,
It is, but I
if
fully
we have
recognise-
to reconsider, we do not have to reconsider on the basis of only of what she knew. Okay, thank you.
That's right. And that's why her fourth statement is relevant. That contains all you need to know on where discussions are now.
I just really wanted to tease that out.
So it's ME4, particularly because it builds on what was said in the second statement, paragraphs 14 to 27, and indeed the fifth statement that's subject to the application to admit, bringing almost bang up to date. And the position appearing from that fourth statement is now that the Secretary of State is obviously very keen, as are the French, to progress matters with as much expedition as possible. See paragraph 27 of the fourth statement. The French Interior Minister has personally agreed there are levels of political influence and clout and so on there as here. And the French Interior Minister, it's important to note, has personally agreed with the assessment that reunification in France should take place.
Current French Interior Minister.
That I'm not sure.
Does France have an Interior Minister at the moment?
I don't know what
I
France
think
has.
there is, yes, there's always been I think that,
Well, we are aware of the change of government.
yes.
In any event, the fact that the then French Interior Minister was taking that position is evident from the updating letter that was sent to the Court of Appeal when all the shenanigan was going on about stay. That's it, on the 15th of November. There was a
So
GLD
what's that updating letter of which you're referring to?
It's an updated letter from GLD to the Court of Appeal of the 15th of November 2024 in supplemental bundle number 1, page 19, and the relevant paragraph indicating that French Interior Minister agreement is at paragraph 16. And it was reiterated, which may go a little way towards answering my Lord's question. If I think of the date of ME5, it may not completely answer it. Date of ME5 is the 13th of December. I'm not sure what developments had happened there. But in
So ME5?
ME5, it's the subject of an
Well,
application.
I've only got up to ME4, I think.
There's a fifth one which I think was sent and it was in supplementary bundle 4.3.
You better just identify this.
Yeah.
I think that
This was last Friday.
Friday, and there's an application notice, I think, to admit it. It starts round about page.
Yes, I see. Well, look, hang
Two.
on. I raised it, as you say, it's 4.3.
It's 4.3, page 7 is the fifth witness statement, after you've gone through the application.
Yeah.
And you'll see for this purpose, paragraph 7.
Well, I've got it. Oh, I see, yes. Well, no, I haven't seen this before.
Right, I'm so sorry, my lord, I should have
Well,
read it.
my lords have, so it's obviously.
I have, so.
Yeah, it's in this.
Yes, but I hadn't been
You
through
haven't
this.
clocked it, well, now I've referred to it, so you've got it now. It's relatively short, but it sets out,
How is the bundle headed?
I think it says 4.3, I'm not sure.
No, what we've got is a supplementary bundle 4,
Yeah.
which has got, however, 3 sections to it,
I see.
described as first. One's called first disclosure, and the second one is called second disclosure, and the third one is called
Fifth state.
evidence. It contains the
So
application.
that's what
notice
I'm
and the
referring
statement.
to as 4.1, 4.2 and 4.3, sorry,
Just while
it's
we're on
tabs.
this, that we've got to eliminate 1 and 2, and then 4, and now I just have a 5. There never was a 3, is that right?
There was a 3, but it went to something different, which was compliance with the order of the
I
application.
see. That fine.
We're not worrying about
Yeah,
it. That was also on the 13th of November. But 5 is of some significance. It brings it bang up to date. The paragraph for present purposes, at least on the 9th of December, the French Minister of the Interior withdrew.
And so yeah, can we just read this to ourselves? 'Cause we haven't seen
Sorry,
this before.
of course.
I don't know why they all seem to say I've made this statement using remote working software. I don't know why that's relevant, but that's not explain more. I don't know really what it means. But that doesn't matter, does it, for anything? No.
I sincerely hope not, 'cause I don't know what
Not
it
AI.
means. The only thing I can give you an assurance about is
No,
it's
that's
not
fine. I just wondered whether there was some significance that I hadn't
No,
picked up. So,
it's not a chatbot statement.
no. Well, let's look at substance.
Only a matter of time, to change.
We'll all be out of a job by then.
Absolutely.
Um,
So it's about the family division, so it's really paragraph 7 for this purpose. But at least on the 9th of December, Bruno will tell you.
we have that fact already, don't we?
You have, but in relation to an earlier date. It was reiterated.
Another discussion.
It's reiterated at that meeting.
I'm not saying you're wrong, but it's a bit confusing.
SB 1, paragraph 19. Page 19. sorry.
Oh, well, I'm not displaying time on it now.
Supplemental bundle number 1, letter of the 15th of November from GLD. Report.
No, don't worry.
It's the same French minister, if I may say. It's
Hang on.
Minister of the Interior of Italy, it's the same person. But he agreed that point then on the 15th of November. And so this is a reiteration in early
It's now clear to me. I must have seen this. These paragraphs are familiar, but never mind. Okay. Yes.
One second, if you would. Not merely have they agreed up to a high political level that reunification should take place in France, but they've also agreed and noted that if the parents agree to accept the children into their care, it would be a pretty quick process to reunite them. But they would either need to claim asylum in France or return to Turkey, and that's fair enough.
Wherever you.
Well,
I'm taking that from paragraph 8A of Mr. Hobbs's statement, supplemental bundle number 2, page 17. paragraph 8A, first sentence of paragraph 8A.
Yeah.
Would that mean that the family court proceedings would no longer have to take place? In other words, the parents' consent. Does that obviate the need for those judicial proceedings, or is it assuming that the family court proceedings will still take place?
I'm not sure what the answer to that is. It may be that there are still best interest considerations that the family court might be interested in.
Yeah.
Even though, as I understand it, the position under Section 20 of the Children Act appears rather more fraught. They could apply for an interim care order, as I understand it.
They're not wards, are they?
They're not.
They're not wards of the court.
No.
They're not wards of court, and they're not subject to an interim care order.
Is there any order in the inherent jurisdiction about their removal? No.
But as I say, they may get interested in, suppose they were to think it was definitely not the best interest of the children. I suspect there are things that could be done by the family court.
Well, I suppose in theory, at least the parents could apply for the family to make application within those proceedings.
Yes, well, the family court might encourage the Kent County Council to take steps if necessary, so.
What lies behind my question, Sir James, is that it depends on what you mean by a quick process.
Yeah.
If the process, at least realistically, does envisage, and I'm not saying this critically, because no doubt there are good and proper reasons why this should happen, but if it envisages the family court proceedings, and I don't know what the answer to this is, whether if on the children's return to France, if that does occur, there might have to be some French family proceedings.
There might. I think the French have reserved that possibility.
Well, I think I'd seen that.
I understand.
Given all of that, then it depends what you mean by a quick process, but I mean, that could be several months at least.
Your observation about quick process was postulated on the parents agreeing, wasn't it?
It was.
If the parents don't agree,
If the parents don't agree, you've got a different world. You've got a different bit of Hague, as I understand it. You've got French social care or social services that would need to get involved at that stage for the purpose of having them into care, which may be more
the
complicated.
French is the sorry. The French are saying if the parents agree, then we can move quickly,
Yeah.
perhaps without worrying about exactly how we do it.
Yeah.
Is that what they're saying?
I think they're saying
Whereas
that
if
with brackets
they
without
do-
prejudice to the, if there are care
I
proceedings,
do
they
object.
could happen in France.
Parents do object.
It becomes more complicated.
Well, I understand that, but my question was really about even if they do consent, whether it's actually going to, depends what you mean by quick. I'm not sure. It's just a question of ticking some boxes and off you go. Because as you said at the outset of your submissions, this is a factual scenario where parents were willing to expose their children to the risk of a channel crossing. Now, I don't know what impact that might have, but at least some court might want to look at the question of whether actually what is in the best interest of children when that's happened.
My lord, I totally understand that, and I don't want to overstate the speed point. We've got various references in the bundles that you've seen to it being a speedy process, but it's a relative thing. If they cooperate and they are engaged and they're engaging with the French authorities, it will be a great deal easier and a great deal quicker than the reverse, as it were. That is not to exclude.
That's obviously so. But speaking for myself, possibly also for my lords, I still haven't got a real picture of what the process is, either if they cooperate or if they don't. There are the English proceedings which are invoke the inherent jurisdiction with apparently a pretty broad, obviously the focus is on whether on reunification with their parents is bound to be, but there's a pretty broad agenda ensuring their best interests. But there are also the Hague procedures, which are not necessarily called proceedings, at least at this stage, which have already started, because there's been an Ikaku request, I believe. But I don't know how those play out. Are the French saying those procedures have to be gone through? There was some suggestion that it might not be Article 8, which is where we asked the French to have them back, but it might be Article 9, where the French asked us to have them back. sorry, I've got the wrong way around, but I would very much welcome just a clear summary of what those procedures are. Then we can perhaps begin to put some sort of time frames on them.
My lord, I think it's difficult to do that with respect. I mean, it's because so much depends on whether or not the parents are going to be actively engaged. And
I understand that, but what if, okay, let's take a best case scenario that they are actively engaged. As my lord says, I would expect that both the English court and the French courts, or at any rate authorities, obviously it would be a lot easier, but they would still have to go through perfectly proper processes. They know nothing about these parents. Everything we hear about them suggests that there will be no problem. But nevertheless, you don't just give children back to parents without finding out something about them.
And all, of course, and all of those things are true. The precise way in which those proper processes, which essentially and at heart have the protection of the children in focus, those proper processes on either or both sides of the channel are, I respectfully submit, proper processes.
Yeah, of course.
And reasonable to be undertaken. Take the English domestic
But
procedure.
Sir James, I'm sorry, I get that. I just want to know what those proper processes are in outline.
Well, the English proceedings, you don't need me to describe.
No,
them.
that's all right. We've got lots of detail about it. I'm more interested in the Hague, the French processes.
Well, I'm not sure I'm able to give you chapter and verse about that because a lot depends upon which bit of Hague you're dealing with and what processes then flow from that. As I understand it, there's either a consensual Hague type process which leads down one road, or there's a transfer of jurisdiction type road that leads down somewhere else, or we have to put them into French social care because the parents are not cooperating road, which is more complicated and likely to be more time.
I'm not sure putting them into French social care, that's a consequence of the Hague processes having worked in order to get them back to France. Obviously, once they're back in France, they will either hopefully be reunited with their parents straight away, but if there are unexpected difficulties about that, they'll have to go to social care because where else would they go? That's not the real point, but the point is what process we got through before they even crossed the channel. I just don't know what those processes are, but it doesn't sound as though anyone has quite worked out the details. Certainly,
It's not entirely clear. As good a reference as any, perhaps the most. If I can just give you one reference. If you go to supplemental bundle, what I call 4.2,
Yeah.
and you go to a note of meetings with French MOJ officials on the 3rd of December,
Yes.
page 59. At least it's got a promising title for my Lord's question in the second bullet point.
Yes.
So maybe this is the best we've got.
Yeah. Well, do you want us to read this
Well,
through?
how-
We've done pre-reading, but we have not read all of these.
No,
I certainly haven't.
I mean, well, that gives you some of the detail. It may be worth just casting an eye.
Well, let's read through it briefly. All this first stage about finding them, we're told, is all a misunderstanding. They've always been willing to say where they are. Here we are.
Well, then great. Maybe the time frame in the second bullet on page 60 applies.
Yeah. I'm not going to attempt to read this in
No,
detail.
but
I can
but
see
then
the
you'll-
sort of thing it is, but
But you'll see
but
the
the
sort of thing.
problem, and who knows whether it's a real problem, and if so, where it emerged, is that nothing had at this stage been done because they thought the parents were in hiding, effectively.
Yes, although it wasn't.
And the evidence we have from the parents is we're not in hiding.
Well, my lord, yes, but there's a difference between the French not being, the parents not being.
I know.
Actively
But
cooperating.
so we really, and then they get on to the Hague questions.
And then the various transfer of jurisdiction, or do you do
Yeah.
social care, or
Well,
whatever, it becomes
well.
more complicated.
I don't think it's a useful. Speaking for myself, I will take advantage of the short adjournment to
To have a look at that.
to have a
My
look.
lord,
That
sorry.
you say is the best indication, though it's slightly elusive, but it's a good note of
The sort of processes that were happening
processes
involved.
involved.
And indeed reinforcing the idea that it's quicker and easier, for obvious reasons, if the parents aren't.
Well,
really
you
involved
keep
in
saying that,
hiding.
and I accept that. That's obviously true.
But subject to a caveat. My broad and principled answer, my lord will understand and has already, which is to the extent that there are processes that are being discussed with the French that might need to happen in France, which will be more or less dependent
Yeah.
for their speed and efficacy on the parents' cooperation. To the extent that those processes are happening in France or may need to happen in France, and that creates time. And exactly the same in relation to the United Kingdom, to the extent that the family proceedings remain live and relevant, and they're interested in best interest for the sort of reasons my Lord Justice Sim was identifying, which one well understand. Forget about the formalities under Section 20 and all the rest of it. Those processes are proper and reasonable to be followed to ensure that the children are only transferred if it's proper to do so
Yeah.
effectively.
And you're going to be coming in due course to the question of the suggestion they could all have been started 2 or 3 months earlier.
Yeah.
Okay. Right, thank you.
But my eighth and short point, which you'll be heartily sick of me giving you, but I give it to you again just in case, and to make sure that the numbers work, is that the time frame and successful implementation of the arrangements would be, and probably would be quite heavily, affected by the willing participation and cooperation of the parents.
Don't we have to assume that they won't?
No, I don't think you do have to assume that. Indeed, I think that would be quite a dangerous assumption. A bit like they won't actually make an application for asylum in France if push comes to shove. Because the alternatives, from the parents' perspective, if that is actually the choices they're confronting, would be worse. So, for example, if the choice confronting the parents is, I either cooperate and increase the chances of my children coming back to me, given their asserted desire for reunification, which is entirely understandable, or the children go into the more complicated route, which would take longer of French care proceedings, effectively, with foster parents outside Paris or whatever, one would naturally expect the parents to cooperate if they're confronted with that choice, to ensure or seek to ensure that the children come to them. And likewise, you saw reference in Mr. Hobbs's statement to the possibility, if they don't make an application for asylum, they have to be returned to Turkey. Well, the answer to that is if they've got a genuine fear of persecution in Turkey, they'll make the application, faute demure. And so you can't make that assumption, I respectfully submit.
Okay.
But the difficulty at the moment is they're a bit in have my cake and eat it territory. And that is difficult. So I would submit that the court's approach should be to take a realistic view of what the parents will ultimately do if push comes to shove. And ninth and finally, the backdrop of the most powerful public interest in achieving a return to France, given the concerns, both broad and particular, that I outlined at the beginning of the submissions.
So sorry, I was just making a further note.
Don't worry.
What was 9? Or
Mine was backdrop of the most powerful public interest, which I'm not going to repeat, both particular and general. I wanted to return, if I may, briefly to the Upper Tribunal judgment, page 221 in the call. And I do it by reference to my 9 facts, as it were. The upper tribunal really paid no attention to the first three of those facts at all. That's the position of the parents and what position they were taking and how it was all going to work. I've made the 3 points that I've made in relation to the parents' position, ultimately it being a preference, and they needed to do that and should have done that if they were considering all of the circumstances bearing on mandatory interim relief, because they did create and do create a strong concern in effect about gaming the system and about disincentivising people from undertaking perilous crossings.
I understand why you've done this, James. You put it in terms of gaming the system. I for myself only, I've been wondering whether there's another way of looking at it, which is whether there's sufficient causal link between what's happened and what needs to happen. That obviously, as you said at the outset, everyone agrees that it would be in the best interest of these children for them to be reunited with their parents. But I'm speaking for myself only. I have been wondering whether at least it is a relevant question to ask: how did they come to be separated?
Yes.
And what part did the parents play in arriving at that consequence?
Yes. Well, my lord,
It might be said it's completely irrelevant and we just have to deal with the situation as it now is. Or I think your submission is that the conduct of the parents is not irrelevant to that inquiry.
certainly not irrelevant when one gets to the harm relied on by the children, which is entirely understandable and understands. No one is saying that there isn't a prospect or a real possibility of harm in relation to children who are separated in these traumatic circumstances from their parents. But the responsibility of the parents is something on which we rely in that respect and as a relevant fact. I was simply really just focusing for the present on the fact that the upper tribunal really didn't place any reliance at all. One can analyse it as a causal thing or a relevant factor to take into account on the parents being able to claim in France, not being unsafe in France, not having a real fear of persecution in France, no prospect of refoulement from France to Turkey, because they can sort that by making an application for asylum if push comes to shove. Justice Baker's question. The UT did rely on the harm to the children for obvious reasons, and no one on this side of the court is disputing that, the importance of that factor. But there aren't really any balancing considerations in the upper tribunal's analysis at paragraph 6. The children are in fact being safely looked after. They remain in contact with the parents. They're going to school. Kent is taking its responsibilities to the parents, to the children seriously. And my Lord Justice Singh's point, the causes of harm must include to a very significant degree the trauma of being separated, no doubt in frightening circumstances, from their parents, when the parents had decided that the family should make the crossing and that the children should be on the leaky boat. And all of that could have been avoided by them making asylum applications in safe Belgium or safe France. And parents are not absolved, we submit, from all responsibility for decisions that place young children, such as these, on these sorts of boats. We see that from the A case, and the prosecution occurred. The public interest in that. And no doubt it's less than ideal for the separation to be prolonged, but again there are balancing considerations that weren't taken into account by the upper tribunal, including the fact that the children are being looked after and are safe, and the fact that the parents can and should speed the reunification process in France, if that is open, as it is. They can't rely on the prolongation if they are choosing to take positions which have the effect of prolonging that reunification. The true remedy, it might be thought, lies in their own hands, and that's, or at least in part in their own hands, subject to the debate we were having about time, and that I respectfully submit is a significant balancing factor that needed to be taken into account and evidently wasn't. That's the second point about the upper tribunal approach to all of this. The next point is that the upper tribunal rejected out of hand, not a serious suggestion, the possibility of return for reunification in France. That's judgment paragraphs 7 and 8. And I submit they had no proper basis to do so, recognising, of course, the time end point, which I will come back to. The route is open to France, The absence of Dublin 3 doesn't preclude that. It simply means that there would need to be discussions with France of precisely the kind that were being, as they acknowledged, albeit early stages, and have continued to be undertaken. There's no recognition by the Upper Tribunal that, particularly given the public interest involved, the Secretary of State was entitled to seek to ensure, as part of rational decision-making, that exploration occurred up to a point trying to get to successful conclusion with France. There's no basis for any conclusion, and none was reached, that they were incapable of being progressed to a successful conclusion. And the Upper Tribunal didn't recognise either the legitimate and very powerful public interest in achieving such a successful conclusion to the discussions with the French. Nor did they recognise the concerns about the English court simply ordering that the parents be given clearance to come here. And the key feature in all of this is, I respectfully submit, the position of those parents. I've dealt with it already. They could facilitate, they could speed up. Instead, what the Upper Tribunal did, see judgment paragraph 8, was to state without identifying what they were, that there were legal barriers to return, as if that was some absolute thing. In fact, the route, albeit with potential complications of the kind you've just been looking at in the December note, could be relatively simple at least if the parents cooperate and are willing to do everything they can to achieve returns. Hard to believe they wouldn't actually wish to do that. And then the Upper Tribunal in the same paragraph criticises the Secretary of State on the basis that she should have given weight to the parents', quote, expressed subjective fears for their own safety of remaining in France. And that, I respectfully submit, is simply not to acknowledge the baselessness of that suggestion. If, as it appears to be, that is a suggestion that France is not a safe country generally, or for these people, or for people of this ethnicity. The Secretary of State was not obliged to proceed on the basis that that was well-founded. On the contrary, the Secretary of State was perfectly entitled to conclude that those expressions of concern were baseless. We are dealing with France, which is signed up to almost every convention that we're signed up to, and is a country governed by the rule of law and a respected member of the EU and all the rest of it. And importantly, the Upper Tribunal do not consider at all the true significance of the parents' position in terms of their ability for speeding reunification in France, which is ultimately what everyone is seeking to achieve. The Upper Tribunal next rejected out of hand, again, judgment paragraph 9, the concerns of the Secretary of State about the risks of opening up an even more dangerous piece of conduct by the gangs. Namely, putting more children on the boats in the confident expectation that if the children get here, the English courts will then order the parents' entry. They ignore, even in relation to that limited subject matter and focus in paragraph 9, the broader point that I made, which is that there is a strong public interest in ensuring that people make their applications for asylum in the safe European countries before they get anywhere near the boats, parents or children. But this was a point about incentivising the gangs to put more children on the boats. And we submit that there is no basis whatever for that rejection by the Upper Tribunal. The judgment is not one for the Upper Tribunal, but is one for the Secretary of State, who is well placed with all of the experience of seeing and understanding how gangs have been operating to make that sort of predictive assessment. Moreover, it might be thought, if one's looking at these things in terms of different species of risk, even a relatively small chance of that happening is of the most serious possible concern for obvious reasons, because it involves exposing children to greater risk. So it isn't little more than speculation, and there isn't no obvious logic to that. The logic is clear and obvious. See our skeleton at paragraph 62. These are incredibly dangerous crossings. It's clear that the figures bear out the nature and extent of that danger year in, year out, with 2024 having been a particularly lethal year. But to go to the logic of it, the parents may have to pay less, simply get the children over, and then will follow without having to pay to get on the boat and to pay the gangs the money. More people in the boats if there are more children, so the gangs get incentivised. More people in because children are lighter. It may make the French intervention more difficult. They might be more cautious, the French, if they know that there are children on board. That's the evidence of Dr. Lemlech. Fourth statement, paragraph 37, makes it absolutely clear. And it's clear that both those who wish to travel and the organised criminal gangs who organise this activity react to changing immigration positions. These are sophisticated, profit-driven criminal organisations. And this concern, at the time of the upper tribunal hearing, was dealt with in some little detail, I have to say, in Lemlech number 1, in one that happened before the hearing, paragraph 11 and following, supplemental bundle, page 291.
Sorry, which paragraphs?
11 and following in Lemlech 1. But that has been expanded in the light of the out-of-hand rejection in the subsequent evidence. See for that purpose, ME second statement, paragraphs 18 to 21, that's in the second supplemental bundle, page 8, and her fourth statement at paragraph 28 and following, and that's in the second supplemental bundle at page 50. And it's important to emphasise finally on this point that the French share those concerns, those precedent effect concerns. See for that purpose, Dan Hobbs's witness statement, paragraph 9, supplemental bundle 2, page 17, and see the exhibit of the same effect, supplemental bundle 2, page 35, and see also Lemlech number 5, which we looked at in whichever bundle it was, 4.3 I think, paragraph 7. So far as timing is concerned, the Secretary of State, we submit, was entitled to take some time to progress the discussions. They could, of course, be shorter or longer, depending upon the position of the parents. But I entirely acknowledge that things did not appear to have progressed with real speed from the position when the parents first took, it appears, in a statement that they made, I think to Kent, but I might be wrong about that, in mid-August. The mother, I think, gave an indication that they did not want to be reunited in France. Goes back to my Lord Justice Baker's question about how seriously one takes that if push really does come to shove. But that indication was given, and it appears that indication was regarded by those who were dealing with the decision making as at least providing a pretty difficult hurdle to overcome, or as it were, even a block. But I fully acknowledge that there was a chunk of time, really in advance of kind of late October, when it picked up again, when, if the world was a better place and everyone had their heads entirely tuned into what they're now tuned into, active steps could and perhaps should have been taken. I entirely acknowledge all of that.
So that's broadly 2 months on the way you're...
It is roughly. And as I say, the explanation appears to have been that everyone seems to have been operating, I don't know, but everyone appears to have been put off at least by the parents saying no and taking that as it were at face value. But it matters not for the purpose of my submissions, because the fundamental point I make is that even at the point of the hearing, it was evident that those discussions, however belated, had started to be undertaken. It was evident and entirely clear that the Secretary of State's preferred position, for all the reasons that were given in evidence that was before the tribunal, public interest reasons, was to seek to achieve a reunification in France if that could be done. And a reasonable time then needed to be built out to enable those things to happen.
That's, I think, candid and realistic of you to accept that there was a time when things could have been done quicker. But you say that really doesn't matter, because by the time this was the judge, it was clear things were happening and that there was a good prospect for reunification. Is that oversimple? Wasn't it open to the judge to say, or wouldn't it be open to us to say, if you had done all this in August, but nevertheless proceedings to be brought at the time they were on the basis it will take too long, you would be a lot further down the road, and the court would, no doubt, say should have been persuaded that no relief was appropriate. But you didn't. We're 2 months down the line. The harm on the children is cumulative. The longer it goes on, the greater it is, the less good the prognosis for an eventual recovery. And a time must come when the courts, applying ultimately Article 8, say you might have had the chance to promote reunification in France, but you missed it.
My lord, I respectfully submit that that wouldn't be open to a court to reach. It would not be open to a court to reach that conclusion. I hope I haven't shied away from acknowledging that steps could and
No, you
should
haven't,
have
but
taken
I'm,
earlier.
yes,
You're putting to me the consequences of
yes,
that.
exactly.
My answer to that is that all of the factors that are in play in this situation need to be weighed. They include the always very easy with hindsight point.
Yeah, of course.
They include that this is a position of some complexity. There are possibilities of proceedings brought by the local authority here. There's possibility in France. There's possibility of this, that, and the other. It's not immediately obvious who's focusing on what, but these are not uncomplex problems when you look at them in the round and in the raw to start off with.
Was this the first time this had actually happened, as far as we know?
My lord, I think.
I mean, there's a maybe in a lorry incident.
Yes, I think there have been some situations, but normally the other way around, where the parents are here and the children are abroad.
Yes, but this
So,
was,
baby case.
we're not told of any other case where the
No.
children had arrived having been separated from the parents at the boat.
No, I'm not aware of any earlier decision. So the complexity is one thing, and the novelty perhaps also of the issues that were involved and how best to deal with that. But my lord also puts to me is this I think the court can say, well, you've missed your boat, as it were. Into that equation, I submit, would have to go the clear and powerful public interest that I identified. They would also have to go into that equation all of the points that I've made about the parents' ability to help themselves and to cooperate, and the responsibility of the parents for the central concern in all of this, which is the continuing potential harm to the children of a prolonged separation. And that is responsibility on the parents, as it were, in
Yes, but-
strong part.
The argument is if the welfare of the child
Yes.
is driving the Lord's concern, the responsibility of the parents is that relevant?
Well, it depends on whether or not you then jump to the position that says, because the Home Office didn't do enough quick enough, the window has closed. And I respectfully submitted that's the game you're playing. All the circumstances, including the ability to bring these things to a quicker conclusion. And after all, if I'm right, and I suspect I am, on the evidence that the thing that really stopped them, or in part was stopping them, was the mother saying, we do not want to be reunited in France, which raised the question of whether that would be forcibly achieved and all the complications that that gives rise to. Leave aside the broader responsibility of putting them in a position of danger which led them to be split out.
So
But
just,
my
when
bro-
you're saying that parents' position, assessing the parents' position during this period was a crucial thing to have to do.
Yes, I do say that, and so my, in a sentence, my answer to my Lord the Vice President's question is that the issues were too important to simply say, we had your chance, it's 2 months, even though you're now discussing it with France, you should have done it earlier. Forget about whose fault it all was, it's mainly your fault because you should have got on with things earlier and seen that you needed to pursue this earlier. The issue is just too important to take that approach, I respectfully submit, including the public interests that are involved. But if I need to, I make points that I do about the responsibility for at least a chunk of that. So that's essentially what we say about,
Yes, thank
about
you.
timing. My lord, the next, I've only got 2 real short submissions to make to conclude. The penultimate one is that the ECHR analysis would, could and should lead to no different conclusion. Everyone, of course, accepts that if you are subject to a positive obligation under Article 8, then that raises different legal considerations under domestic law, because if you're subject to the duty you are subject to under Section 6 of the Human Rights.
Just so I can get this clear in my head, you say ECHR as if we hadn't been talking about the ECHR beforehand, but most of this has been underpinned by the ECHR. The claim is a claim based on Article 8 and indeed Article 3. But
Well, it is. We haven't not been dealing with this.
yes,
but,
I see.
But we've got the kind of rationality bit, and then we've got the ECHR
Yes, I
bit,
see,
so
okay.
they're slightly different in principle anyway. I'm not seeking to silo this, as it were, so that to the exclusion of all the points I've already made. My point is that they feed just as well into an ECHR analysis as they do into a public law analysis. The upper tribunal dealt with that aspect at paragraph 5 of its judgment. If you just go back to that. And I wanted really to pick up on the second and the third enumerated points in paragraph 5. Again, I don't want to do a disservice to Judge Kamara in relation to the second one. I'm pretty sure she wasn't labouring under misapprehension, despite the fact that it looks like it's being set out as an absolute proposition. I'm pretty sure she was aware that Article 8 requires balancing to be done.
Yeah.
So I'm not going to accuse her or accuse her too hard of setting out half a principle. There certainly can be an obligation of a positive kind inherent in Article 8 to achieve immediate reunification. But that is the core point. I'm not sure if she does acknowledge this in turn. That is a question of fact. The principle is not absolute, requiring a state simply to admit parents. There are balances inherent in Article 8, and it's a fact-dependent analysis. That's absolutely evident from the case law. Again, I haven't got time, and I don't propose to go back through that very well-known case law. Jeunesse, we referred to it in our skeleton at paragraphs 28 and following. Jeunesse in the Netherlands, can I just give you some references? Jeunesse in the Netherlands, paras 107 to 109. That's in tab 41 of the authorities at page 922. Lebanon and the Secretary of State, paragraph 41, authorities bundle tab 20, page 308. ZH Tanzania and the Secretary of State, para 29, authorities bundle 16, page 212. But there's nothing in the European Court of Human Rights jurisprudence to suggest, under that case law or any other, what should occur if there are effectively two different options, two different geographical locations for achieving reunification. There's nothing to preclude, to put it positively, the return of illegal entrant children to the safe third country like France, where the parents are located. On the contrary, if anything, under that case law, the children can be expected to go to where the parents are, and we've given you the case law that supports that proposition in our skeleton at paragraph 32. That's KO Nigeria. Sorry, my lord.
Forgive me, Sir James. And can that be done as a matter of law without determining the children's application for asylum on its substantive merits? So can you short circuit that process as
My lord, my submission is that you can, if that's the right way of viewing those issues. I think that was the clear and provisional view, if provisional view, of Mrs. Justice Gwyneth Knowles in the judgment that I referred you to, the re-care proceedings.
This year.
Exactly, this year, which is in Authorities Bundle 35, page 732. And the key paragraphs are perhaps 68 to 71. And it would stand to reason, if you need to achieve super speedy reunification to protect the best interests of the children, you'd have thought that would be pretty self-evident. And as I say, we've given you the case law that supports that at least being the starting point. Children go to parents rather than the other way around. and it's KO Nigeria, paragraphs 18 and 19, authorities 22, page 386, and it's NA Bangladesh, N for Nanny, A Bangladesh, paragraph 30, authorities bundle 28, page 531. And perhaps quite importantly to note, the courts have acknowledged that in this context, both A, the public interests involved, and B, the extent to which the individual has contributed to the situation in which they find themselves, both of those things feed into the Article 8 balance. And we've given you the case law in our skeleton at paragraph 33. The key one is perhaps AM Belarus, paragraph 87, authorities tab 32, page 674.
Not sure how that applies in the case of children.
No, well, it may or may not do, but in principle, those matters are relevant to be taken into account. So I respectfully submit that if one goes back to the judgment against that backdrop of principle, it doesn't do justice to the principled approach that truly needed to be followed. They relied on two specific cases. Again, I've made my submissions in relation to those in writing, so I can take it shortly. The first one was the MIK case in Strasbourg. The short submission on that is it's just not remotely analogous.
Well, you say about both these are cases of children going to parents, not parents going to children.
I do, and different for all sorts of other reasons as well. We've set out the arguments on that in our skeleton, 34 to 35 and 48 on Mayeka, and also in relation to the Syrian baby case. The Syrian baby case might be thought to be an application of the common sense starting point that children go to parents, rather than the other way around. Finally then, the no proper basis for the conclusions on balance of convenience. There is a very powerful public interest in not making a mandatory order with all of the serious concerns about impact, at least until it's entirely evident that there is no realistic route for return to France. And the weight of the public interest when considering interim relief in the judicial review is clear, and you'll remember it being acknowledged by Lady Justice Lang in the passages you looked at in RRR, I think taken from medical justice, those references. And there is here a very powerful public interest in not allowing parents in safe France to seek to place obstacles in the way of what would otherwise be a clear and available route to reunification in France on the basis of unfounded concerns about their safety in France. There are of course concerns about the children, but the route to bringing any harm from continuing separation to an end is open. The parents can significantly assist in both the success and the speed of that, and indeed can't rely, we submit, legitimately on unfounded concerns to say they don't want to reunify in France, so the children must be subjected to delay in reunification, but in the meantime the children are being safely looked after. The suggestion then that the parents can come here, be admitted by mandatory order, and then the family, if it all turns out the other way around, can be removed, we've discussed already, that clearly places the Secretary of State in a considerably worse position. And indeed the Secretary of State is the headline first point, is properly entitled to take the position that if the route for return to France is, or within a reasonable time may well be open, then she wants to continue the exploration without admitting the parents in the first instance. That's a perfectly proper position she's entitled to take, both as a matter of common law and under Article 8. And we discussed the position that at present there would be, on any view of the Strasbourg jurisprudence, Article 8 obligations on the French government, where the parents are currently located to assist in achieving reunification. may well have formed some part in their agreeing that this was a good idea to pursue. But they would be subject to those, and that would be lost if the parents were to come here. That's a very significant legal disbenefit that would flow from that. But there is the broader and more practical concern here, which is that once you've forced, as it were, the Secretary of State to admit the parents, then what happens is, in the real world, that everything then, as I put it earlier, winds its weary way, and the processes take forever, and different claims are made, and one claim is lost and the next one is introduced, and we have all of the problems that are inherent and that everyone is deeply focused on trying to sort out with the speed and efficiency of the immigration system and removals. That's all part and parcel of the picture. But the broader and overarching point remains that the best way of achieving the public interest aims which underpin the position the Secretary of State has taken, the best way of achieving those public interest benefits is, if possible, to secure a return of these children to be reunified with the family and father. So, my lord, those are my submissions in open.
Can I just ask one question?
Yes.
Suppose, and of course I'm advancing this only for the sake of argument, we agreed that the application and the judge's order were premature, which is exactly how it was put below, but that we also recognised that in principle there would come a time when it was all simply taking too long, was too uncertain. What is the machinery for saying, I still resisted, but what is the machinery for saying that a time has come when we really have to allow entry clearance because it's getting nowhere?
Well, my lord, I think the answer to that in immediate and pragmatic terms is that we have a hearing on the 9th of January in the upper tribunal on the main event.
Yes.
So that provides you with something of a long stop, but if you strip that out for the sake of argument and address the point as a question of principle, I think the answer to that would be if you say it's all premature and overturn the decision of the upper tribunal judge, so the position is status quo remains, as it were, unless until it becomes apparent.
Yes.
The answer to your question would be that it would be open to claimants to go back to the upper tribunal and say enough is enough.
Bring fresh proceedings.
Enough is enough.
Yeah. Okay. Thank you.
My Lord, can I just rise very briefly? My Lord, Lord Justice Baker asked a question effectively about how common this situation was, as I understood the question. I've taken some instructions. I can give some information on that if it would assist.
Yes, it is on precisely this situation. It's not just unaccompanied children.
Well, no, that was exactly the distinction I wanted to make, was that Kent obviously had considerable experience of unaccompanied asylum-seeking children. In its experience, it is rare, it's very rare, to locate the parents overseas, and it has never had to deal with a situation where such young children have been separated from their parents at point of departure from France.
Thank you very much. Yes, Ms. Kilroy.
My lord, can I just check first that you have the chronology that the respondents have submitted?
I don't have a chronology. I would have liked to. I've done one for myself. Where should we have had it?
I'm going to hand up copies of it. It should have come through yesterday, together with a glossary, which helps you navigate the skeleton argument.
Well,
I'm afraid there's so many papers. We'll hand them up after lunch. So, my lord, I will start, obviously, with 7 minutes to go, my submissions on this. It is the respondent's position that the judge was unquestionably correct to grant interim relief in this case. Not only did the judge make no error of law, but in a case which pleaded a breach of Article 3 and 8 of the Convention, for which she had granted permission, it was the only decision she could properly take when applying the balance of convenience test. She had before her, on the 31st of October 2024, a crescendo of evidence from foster carers and medical professionals showing escalating harm to the children. A qualified psychiatrist told her that there had already been a need for urgent reunification in days, a month before the hearing, and that there was serious concern about long-term, irreversible damage to the children's mental and physical health from any further delay, and furthermore, that no intervention could alleviate that harm, save for reunification with the parents. That psychiatrist also told the upper tribunal that from a child-centred perspective, it would not be in their best interests to be reunified in France as opposed to the UK, and there remains before this court no evidence to contradict that expert view. These two small children, aged 6 and 9, are likely already to have suffered irrevocable, lifelong damage from what is now 5 months of separation from their parents, and that damage worsens day by day. Making them wait on what is a best case scenario, a further 2 months. This is in relation to the family proceedings to find out whether the family division agrees with the evidence before this court about harm, or whether it might be possible to remove them to France, in the full knowledge of the damage that that would cause those children. In my submission would be unconscionable as a matter of simple humanity, but it goes beyond that. It would be a clear breach of this country's obligations under Article 3 of the European Convention. And I'm going to take you to that case law by reference to the harm in this case. But my lord, I want to highlight before the break a few points in response to what my learned friend has said. The first is that it is the parents who are responsible for this, and therefore that less weight should be given to the harm to the children. My lord, that is not a permissible approach to take to the assessment of what should occur in this case. You must consider the matter from the children's perspective and the harm that it will do to them. And there is authority in the bundle, tab 17, it's Zumbas, pages 217 to 226, paragraph 10, which explicitly says that children must not be made to suffer for the conduct of their parents. But in any event, I do not accept on the parents' behalf the responsibility for what has occurred in this case, in other words, the delay. Delay is a key issue in this case, and my learned friend has sought to put it down to human failings and to brush it under the carpet, coming to it absolutely last in his submissions for obvious reasons. But in fact, the delay is critical here because the Secretary of State did nothing at all when these children arrived, except plan for their arrival on a boat. And you can see, and I will show you after the break, and the references are in the skeleton argument, the correspondence between Kent and the Secretary of State in which they explicitly planned for the expected arrival of these parents to join these children unlawfully. The children have been told for months to expect their parents to arrive, first unlawfully on the boat, which they were terrified about, and the social worker talks about the impact on them of that. And secondly, by the lawful means that they were attempting to use and have used, the entry clearance process. So the Secretary of State started by doing nothing because she expected the smugglers to bring the parents to the United Kingdom. And then when the parents decided to use the lawful means that are available to them by the entry clearance process, she also did nothing. And even by the point of the upper tribunal decision, and I do urge you to read carefully the evidence that was before the tribunal, and particularly Miss Farman's statement and the first of Miss Emilik's statements, the Secretary of State was still arguing on the 31st of October that there was no particular hurry which should be applied to this case. She had agreed to expedite it, but she had at that late point, but she was still arguing that she should be given an unspecified amount of time to start and continue the negotiations, which, as we've seen, only began 2 days before that hearing. So the Secretary of State did not consider this a priority, had not taken the harm to the children into account. And what in fact happened is that the speed that has now been applied to this, the evidence that has been put before you, the arguments that have been made in detail today about the communications with the French authorities, the investigation of the family law mechanisms, all of that happened afterwards. At the point that the upper tribunal judge considered this matter, there was no indication whatsoever that this sort of approach would be taken by the Secretary of State, that the Secretary of State had even considered the legal obstacles that applied to the reunification of children with their parents in France, whether no mention of Hague or any of these other applicable treaties. And so she was, in my respectful submission, clearly right to conclude on the basis of what she had in front of her that not enough had been done, that the delay had caused these children serious harm already, and that no further delay could be justified in the circumstances of this case. And just briefly, the other key aspect of this decision, which I urge you to take into account, is the fact that this was an accidental separation. Now, the public interest that the Secretary of State invokes in this case relates to potential deliberate separations in future as a response to what occurred here. But this was an accidental separation, and that would be critical to any judgment, and is critical to the judgment that the upper tribunal judge made. There was no gaming the system for this family. They planned to come here.
I don't think any of this has been controversied. There's been talk about gaming the system later.
Yes.
But nobody is suggesting this was anything but an accidental separation.
Well, but my lord, that is relevant because the precedent that it sets must relate to the facts of this case. As your lordship observed in the course of argument, it is when whatever judgment a judge reaches, either in this court or in the upper tribunal, will be relevant to what the either future entrance to the UK or the people smugglers, if they find out about it, will depend on the basis on which the order for admission is made. And in this case, there has been egregious delay. Presumably in future cases there would not be. And there was also accidental separation, not deliberate. But I will leave it there because...
Thank you very much. 2 o'clock.
Rise in favour.